Korean companies' intangible assets, including patents, account for 57% average of total value. For U.S. companies, this percentage is even higher, with intangible assets rising up to 90% for S&P 500 companies. Among these intangible assets, patents play the most significant role in enhancing a company's value. However, a patent becomes an asset only when the hard work of many experts come together. The researchers who develop the technology, the patent attorneys who translate the technology into patent language, and the examiners and judges who grant those rights. In that sense, I would like to express my gratitude and admiration to all of you here today who work tirelessly to enhance the value of companies through your efforts. Distinguished guests, as we witness the rise of economic blocks, partnerships among like-minded countries have become a key factor not only at the national level but also for our businesses. The KOIPA U.S. alliance, which began 7 decades ago as a military alliance, has evolved into one of the strongest and most comprehensive economic partnerships over the years. And now, one of the most essential aspects of our bilateral alliance is our critical in emerging technology cooperation. Recently, we have witnessed growing investment and cooperation between our two countries in critical technologies like semiconductors and batteries. Last year, Korea was the #1 foreign investor in the United States by investing over $21.5 billion, and Korean companies created the most number of new jobs through such investments. Such trend of close economic partnership is also evident in terms of patent filings. The U.S. files the most patents in Korea, and Korea ranks 4th in the United States. Notably, Korea's Samsung and LG were the top 2 companies in patent grants in the U.S. last year, even surpassing U.S. companies. However, as the number of patent filings rose, so does the number of patent disputes involving Korean companies operating in the United States. Based on publicly available data, Korean companies were involved in 107 patent lawsuits in the U.S. last year. Of these, Korean companies were defendants in 84 cases and plaintiffs in the rest. Contrary to the common belief that patent lawsuits are the domain of large companies, 34 of these cases, about 1/3, involved small and medium-sized enterprises. In particular, Korean SMEs have been active in securing their patent rights, with 19 of 34 cases, more than half, being initiated by as plaintiffs. Additionally, over the past 5 years, the U.S. International Trade Commission has initiated 35 investigations against Korean companies for alleged intellectual property infringements. With such rising trend of IP disputes, it is timely that today's forum is under the theme of protecting IP for enhancing corporate competitiveness. Distinguished guests, I would like to point out that this forum is being held in the Edison Hall. As you all know, Thomas Edison was one of the most innovative, ingenious inventors and entrepreneurs in the American history. The driving force behind Edison's success as an inventor was none other than patents. He obtained more than 1,000 patents and used them, many of them to fund his next research. He also actively engaged in patent litigation to protect his intellectual property and sustain his business. I hope that the discussions on IP protection strategies here today will establish a firm foundation for creating and growing innovative companies like Edison's, both in Korea and the United States. Our embassy in the United States also remains committed to helping Korean companies quickly acquire their intellectual properties and protect their IPs in case of disputes. In closing, I would like to express my deepest gratitude to the KOIPA IP Center and PCT Korea for their efforts in organizing these events, and all the participants who were here, and then wish you have a very productive day today. Thank you very much.
Good morning, everyone. It's very much a pleasure to be here today. I'd like to thank Minister An, as well as the host of this great forum for this opportunity, and also in particular the Korean Intellectual Property Office, the Embassy of Korea to the United States. We at the USPTO and at the Patent Trial Appeal Board, or PTAB specifically, welcome this opportunity to engage with you. As said by Minister An, the Republic of Korea and the Korean Intellectual Property Office has been and continues to be a key strategic partner for the United States and the USPTO. And this forum is just another effort towards a productive exchange of ideas that benefits both of our great nations. I'm also impressed by the diverse array and caliber of the speakers. Many of you from law firms, companies, as well as high-level government officials, some coming all the way from Korea itself, such as IPTAB Interim President Yeon Jung, to be with us today and share updates and views. So since I am representing PTAB, I thought I'd like to take this opportunity to share some things about us from our perspective, focusing on something old, something new, and hopefully something a little familiar. So starting with something old, I wanted to share some brief thoughts on the history of the PTAB. We have a proud history that goes back over 150 years, when in 1861, President Abraham Lincoln nominated Silas Hodges, George Harding, and Thomas Speaker as the first 3 examiners-in-chief for the newly formed Board of Examiners-in-Chief. About 35 people were appointed to the Board of Examiner-in-Chief over the years. Before 1927, the name was changed to the Board of Appeals, and in 1939, this was also joined by the Board of Interferences. And there's 2 people from this era that really had an outsized impact on patent law, in my opinion. The first was P.J. Federico. So he was appointed to the board in 1947, served in that role for 33 years. He's probably better known as the editor-in-chief of the Journal of the Patent and Trademark Office Society, and he was also, more importantly, behind the scenes, according to the late Judge Rich, was the person most responsible for getting the 1952 Patent Act through Congress, and his writings are very much still cited today. And the other is Luttrell F. Parker. So he was appointed in 1970, and although our records are kind of incomplete, we believe he's the first and only person from the board who later served as both Deputy Commissioner and Acting Commissioner of the USPTO. And this feat, to me, is made even more impressive by the fact that we also believe he was the first African American to serve on the board. So at least another 80 people served on both the Board of Appeals and Board of Interferences before in 1984 the 2 boards merged and became the Board of Patent Appeals and Interferences, or BPAI. In 1993, what were examiner-in-chiefs were renamed administrative patent judges. That was formally codified in 1999. And finally, in 2011, under the Leahy-Smith American Defense Act, that was passed. In 2012, that reformed the BPAI into the PTAB, which also established regional offices. And I only mention that because we at PTAB are proud that we had the distinction of having among the first USPTO employees on the ground in Detroit, Denver, Dallas, and San Jose. So today we have about 230 administrative patent judges. We're spread out all across the country, and we proudly serve to promote the integrity of the patent system by impartially resolving patentability disputes, both in ex-parte appeals as well as AIA trial proceedings. So turning to something new, this has been a busy year at the USPTO for rulemaking, and we at PTAB are no different in that regard. For example, in June, we issued final rules on pre-issuance, internal circulation, and review of PTAB decisions. So what this did is it formalized current USPTO procedures and made clear that PTAB judges are to exercise their judicial independence and that the director is not involved in directing or otherwise influencing PTAB panel decisions prior to the issuance of the panel's decision. In September, we issued a final rule on motion to amend. So this formalized a pilot program which provides patent owners who file a motion to amend a couple options. One, they can request preliminary guidance from the PTAB to file, and they can also file a revised motion to amend. And this rule package also revises rules that allocate burdens of persuasion at the PTAB. In October, we issued a final rule on the director review process. So this formalized key aspects of the interim director review process, which was implemented after the Supreme Court decision in Arthrex. And it provides that a party to an AI proceeding can request director review in that proceeding of any decision on institution, final decision, decision granting rehearing, or any other decision concluding an AI proceeding. And finally, we issued a final rule recently on expanding opportunities to appear before the PTAB. This allows parties to proceed without backup counsel on a showing of good cause, and also establishes a simplified and expedited process by which parties can request pro hoc vice admission. So with that, I'll end with something familiar. So as you know, the USPTO and the Korean Intellectual Property Office have been increasing collaboration at all levels through the IP5 framework, for example, and the trial and appeal boards are no different. In parallel with the annual meetings of the heads of the IP5 offices, the trial and appeal boards over the last couple of years have also been holding annual meetings. And the latest meeting was hosted in person by the KOIPA IPTAB in Seoul, Korea. The themes for the meeting included several things, including updates on recent developments, including key initiative in areas of interest, as well as digitalizations of proceedings and the use of artificial intelligence. So at that meeting, some of the USPTO AI initiatives were discussed, such as in February of 2024, Director Vidal issued inventorship guidance for AI-assisted inventions. So this makes clear that AI-assisted inventions are not categorically unpatentable, and it also provides instructions to examiners and stakeholders on how to determine whether the human contribution to an innovation is significant enough to qualify for a patent when AI also contributed. And in April of 2024, the USPTO issued guidance on the use of AI-based tools in practice for the USPTO. So this reminds individuals involved in USPTO proceedings of the pertinent rules and policies, and helps inform those same individuals of the risks associated with AI and provides some suggestions to help motivate those risks. So not only did these delegations have a productive exchange of information discussion, but also provided an opportunity to address the public, which was an opportunity that we at USPTO and PTAB really appreciated. It was an event that seemed to be well attended and very well received. So the USPTO and the PTAB look forward to further collaboration with KIPO and the IPTAB through the IP5 and other frameworks. And again, I thank you very much for the opportunity to speak with you today. I will now take a seat to learn what I can from you all. Thank you.
I have taught patent law now for 35 years. Yes, I started in 1989 at the University of Virginia. I was just mentioning to Judge Kim that his boss was actually one of my students at the University of Virginia. I mention this because I want to tell you about the best patent law class I have had in 35 years. I went to Seoul National University about 5 or 6 years ago at the invitation of Professor Jung. Now we all know he's not really Korean. His name would be Kim Park On or Han if he was really Korean. Of course he's Korean, but he has a Chinese name. I had a class of about 150 students in the largest classroom at Seoul National University, and we actually had to bring in chairs along the side because they only had 120 seats. This was a wonderful class. The Korean students are just amazing. It's the only class I can remember where I would mention a decision and teach a decision as part of the U.S. system of Socratic examination of case law. And the Korean students would come back and say, but there was a footnote in one of your opinions in 1994 that said something different. They would look up all my decisions. I was very impressed with those Korean students, and I still write recommendations for several of them. Now, this is an important time in U.S. Political history. We are engaged in a presidential election. I will not get to see the results. Now, I've already voted, but I am flying to Korea on election day. I am going to address, I think it's the 20th anniversary of the patent court in Dijon. When that court was created, I spent several days with the chief administrative judge who was organizing the court, and I advised him on setting up that court and its procedures. And so I'm going to return to commemorate that important event. I'm looking forward to it very much. You will know the results of the election before me. I'd like to tell just one or two quick stories that are very pertinent to this group. Since leaving the bench, I have often consulted by corporate counsel about litigation strategy. Just shortly after I'd left, I was at a very important board meeting. And they introduced me by saying, we have invited Judge Rader, Chief Judge Rader, to give us advice on which court we should use for a very important patent case. The attorney who introduced me said, actually, we're taking bets. Some people are betting Texas, other people are betting Delaware. And I stood up and addressed the board and I said, who voted for Delaware? There were some hands. Who voted for Texas? There were some hands. And I said, you all lost. I'm going to tell you to go to Dusseldorf. I need to update that story today. Today when I'm consulted, I very often advise corporate counsel to go to Asia. And prominent on my list is the Korean courts. It's a simple reason. The U.S. courts are too expensive and they take too long. It will take you 4 years at a minimum. Actually, I've been working with an important Korean client on battery technology, and that case never ends here in the United States. It's wiser to go to Korea. And I was informed of just today that you can actually argue before the Korean Patent Court in English. Now that is impressive. I'll tell you the reason why they have to do that. They're in competition with the UPC in Europe, and 70% of the proceedings in Europe are held in English. Korea is smart. They're ahead of Japan, they're ahead of China, they're ahead of all the other Asian courts in offering an English alternative. Today, if I'm asked which court you should go to, I won't tell you Texas, I won't tell you Delaware, I will tell you Korea. You can do it in English. It won't cost you as much. It will be done in a year. Now, my actual topic today is the importance of intellectual property for competitiveness. I figure I don't need to tell you much about that. You know, I've got one of these. It's 3 years old, which means I'm already ancient history. My son won't even send me messages on this because it's an 11. And I should be using a 16. The point is, what makes you competitive is new technology. This changes twice a year. You know that. I can tell you Samsung knows that. I can tell you LG knows that. New technology is what controls the marketplace. And I've mentioned this device, but this is also a healthcare device, as you know. And the future is tied up in new technology. And how do you guarantee that your new technology will control the market? You get a patent. I think it was in the end of the Bush administration, second Bush administration. I was the chief judge and I got a call from a close friend of mine who was Bush's director at the United States Patent and Trademark Office, and he said, "We're considering expanding the cooperation amongst patent offices. We're thinking of making it a 5-office cooperation." It had been 3 for years, Europe, Japan, and the United States. The big question, of course, you had to add China because they were filing more patents than anyone else. The big question was, do you add Korea? And I said, absolutely. Because their patents One of theirs is worth 5 in China, maybe 10. Well, as you know, that did happen. And it has been, as Judge Kim pointed out this morning, an important step forward in the cooperation of our nations in advancing technology. The patent is only as good as its enforcement, however. And that means no matter what the strength of your patent, you're going to have the ability to enforce it. I hate to say this, but it's true. That means you're going to have to bring a lawsuit. Now, you can urge people to license your technology. The standard wisdom is you don't license until you're required to. That requirement comes in the form of a lawsuit. And that brings me back to the 2 stories I started with. Korea has magnificent legal talent. Those students who took my class are not just them, they are representative of a whole generation which is dedicated to advancing technology and understanding how to enforce patents. If you're a U.S. law firm and you don't have a Korean patent attorney yet, you're in trouble. But I have a feeling that's why you're here, because you do. And that brings me to the other story, which is use that Korean patent attorney to bring your case in Korea. You can do it in English. That cooperation between the U.S. and Korea is probably the leading technological cooperation in the world. You cannot afford to miss the opportunity to control the market through that Korea-U.S. cooperation. Thank you very much.
Naturally involves multiple countries and jurisdictions. But in today's discussion, we will be focusing our discussion on the United States. And on the panel today, we have legal and industry experts with lots of actual and legal experiences. And without further ado, we will jump into our panel discussion. And Mr. Minwoo Park will lead off with a discussion regarding ITC investigations at the United States International Trade and Commission. Thank you.
Hi, good morning, everyone. My name is Min Park, and I'm with the firm of Morgan Lewis. And first, I would like to thank you for inviting me as a speaker today. So here, I'm here today to talk about the ITC, along with a couple of other panelists who have really interesting stories that relate to ITC. So, but since I'm the first speaker, I'm gonna introduce very briefly about what the ITC is, and also after that discuss a couple of things that I think are very important for to know for today's attendees from Korea. So the ITC is actually a federal agency. I think it's often misunderstood as a specialized court of some sort that address IP issues, but that's not the case. It's actually a federal agency, and it has expertise in trade-related issues, as the name suggests. Right? So the things that the ITC does are, for example, lending expertise to different branches of the government, such as the executive government, executive branch, and the legislative branch. Also, it determines the impact of imported goods on the U.S. industries. So as part of these types of work that ITC does, it conducts what is called Section 337 investigations, and we simply refer to them as ITC investigations or ITC litigation. And this process is very much like a litigation, a judicial proceeding, in that there's two parties, and discovery happens, and at the end there's an evidentiary hearing and all that. But because the ITC is technically not a court, it's not bound by all the rules that a court has to adhere to. There are some very interesting differences between the ITC, or how the ITC conducts its investigations, and how a district court proceeding, for example, patent infringement litigation proceeds. And I'm sure many of you know some of these differences, such as the speed at which the ITC investigation proceeds. And once it starts, it's kind of like a moving train, like with a lot of momentum. It just cannot be stopped. Even if you fire an IPR, it just goes on, right? So that's one feature that everyone's familiar with. And also, ITC allows very broad discovery, lots of interrogatories, lots of other discovery requests. So it allows discovery, very extensive discovery to take place. But I think one difference that really everyone, especially the Korean audience, should get to know about the ITC is that its remedies, which are exclusion order and cease and desist order, that basically stops importation of products into the United States, and also stops sales of products that have already been imported into the United States. Those remedies are not directed at the parties, but they're directed at the imported goods themselves. So at the end, if the ITC finds a violation, what it's going to do is it's not going to tell the respondents to stop importing. Instead, what it's going to do is it's going to instruct the Customs and Border Protection Office to stop. A representative of the office right here, actually, so you can ask questions about that. But it's going to tell Customs to stop importation of violated products into the United States. Right? And because of that difference, ITC can really simplify the process that are required for personal jurisdiction, establish personal jurisdiction over the respondents, right? So at a district court, in order to establish personal jurisdiction, you have to go through this very complex process of serving the complaint and summons on the defendant. And in certain cases, when the respondent or the defendants are located entirely outside of the US and has no presence in the US, that process can take months, if not years, right? So in that way, a foreign defendant that has no presence in the United States can buy a lot of time. And those entities often misunderstand. They also have that much time to respond to an ITC complaint. But that's not the case. So once, actually previous slide, once the ITC institutes an investigation and serves the complaint on the respondents have only 20 days to reply to the complaint. And the service requirement here is really simple. ITC does it itself, right? And all it does is deliver the complaint by express mail, and that's the end of service requirement. And actually for foreign respondents that do not have a presence in the US, the complaint can be actually delivered to the embassy of the country in which the respondents reside. So, all these embassies are in the US, and the ITC is also in the US, so it's just local delivery, right? Even Uber Eats can do that kind of delivery in a single day, right? So it's really simple. So after that point, you only have 20 days. Every single day of those 20 days will count, because it's gonna take a lot of time to prepare that complaint, right? So you should get to know as soon as possible when you're sued at the ITC, and get to work on day 0 when you find out that you've been sued. And in order to be ready to do that, right, you should get to know at least one law firm or a lawyer that has previous ITC experience. So that's one message that I really want to get across to you. And the other one is, can we go to the next slide, please? ITC is also often misunderstood as a venue only for patent infringement. And that misconception can be understood if you look at the stats from the ITC itself. The number of patent infringement cases is really overwhelming. They're much larger than other causes of action. I think it's more than 90% cases. But the ITC will take other claims as well. For example, trade secret misappropriation. And antitrust claims can be heard at the ITC as well. And false advertising is another cause of action that ITC will hear. And recently, I was involved in a case where the sole surviving claim by the time of the hearing was conversion and theft. So again, that's an unfair act that relates to trade, and ITC will hear such causes of action. So it's not just patent infringement. There are all these other causes of action that can be brought. And of these, I think the one that's very interesting and one that is very relevant to what's happening in Korea right now is trade secret misappropriation. Could we go to the next slide, please? So if I look at the Korean newspaper websites these days, I see a lot of articles like this. Increasing number of trade secrets being stolen by competitors, right? And it seems like the entire act of misappropriation is taking place within Korea or involving other countries in Asia, right? Such as China, other countries in Southeast Asia that have manufacturing facilities and so on. So if that's the case, if the entire act of misappropriation is taking place outside of the United States, it will be difficult for you to bring a case at a U.S. district court, because a U.S. district court will require at least some act in furtherance of the misappropriation take place in the U.S., or the misappropriator be a U.S. citizen or a U.S. entity, right? So, but based on things that I've read in Korean newspaper articles, it's going to be a challenge to meet those requirements for district court litigation. But the ITC will hear those cases. As long as the products that are being imported by the missile appropriator into the United States have a connection to the trade secret that was stolen from them. So I think the trade secret missile appropriation is very underutilized at the ITC. I think it presents a very good opportunity for Korean companies to exploit. So I highly encourage Korean companies to consider the ITC as the venue for your trade secret litigation. And I think I've taken up enough time already, so I'll pass on the microphone.
Thank you very much for that. Does anybody from the audience have any questions? He's a leading expert in ITC, so I would encourage you to get some free legal advice here. I got a question for you. So what are some factors to consider when deciding to file a complaint at the ITC as opposed to filing litigation?
So compared to district court, filing at the ITC, one main difference obviously is the requirement of domestic industry. So you have to demonstrate that you have an established domestic industry in the US, or at least you are in the process of developing a domestic industry. So that's a major requirement that you have to show in order to get a remedy from the ITC. Right? And I think it can be challenging for foreign entities to show that, but many Korean companies have shown that before, so it's not impossible. And I think with just some adjustments of your business, it can be achieved. Sometimes it's quite easily, or you may already have domestic industry in the US. So that's one major consideration. Second, I don't know, perhaps speed is one. I mean, it's fast for you, it's fast for the respondent, so that can be a plus or minus, right? And because of the speed, I think as a complainant, if you want to file your case at the NTC, you really have to put your case together. With respect to at least domestic industry, you have to get all your evidence together, you have to have a strong case. So there's a lot of preparation to be done before you file an IPC case.
Thank you. Does anybody from the audience have any questions for Dr. Park? Okay. So next we'll hear from Mr. Sean Young, and he's the president and CEO of VectorNate USA. And his company recently went through an ITC investigation. And he will share his experiences from a client and industry perspective.
John, do you mind if I stand up? Okay. I'm not really smart as Mr. Park, so I cannot memorize the slides. Alright, nice meeting you guys. I'm Sean, the president and business owner of the Meshaker. We sell medical supplies and consumables out of New Jersey right now. Next slide, please. So we, next one, please. Yeah, so we, COVID, I'm sure for everyone, but made a big turnover event for us. We had to, ramp up the manufacturing. We do medical device, but we used to do almost nothing, but had to produce like hundreds of millions of swabs for testings and supplies. So it was crazy, and especially at the middle of COVID, we had to get the raw materials, equipment, and Korean government was controlling the exports, and we couldn't export properly as well. Shipping was crazy, so it was really, like I worked literally 24/7, day and night. And what happened after that? Next one, please. So I still remember this date. I think it was middle of August 2021. I came to office, and the thick FedEx envelope was sitting on top of my desk. I didn't know what that was. I didn't even want to open it, but opened it, and I was saying, because I'm not a lawyer or anything, so I didn't really understand terminology, but was saying section 337, investigation, respondent, list of like 10 to 15 companies. I'm one of them. I see like big national companies, like big national medical device companies. We are included one of them. Literally I was panicking, and I didn't know what to do. I knew there was a deadline, but I think I probably did nothing for 2 days. Like had a mental breakdown probably, because I had employees to take care of. Company was selling so many swabs, and customers were asking tons of the medical supplies. I was busy with that, and I was wondering why is this happening to me? I thought this is only for Samsung. No offense to Samsung, but I didn't really understand. So next slide, please. So I mixture of feelings were kicking in. I was thinking, do I need to confront them, fight with them, saying like I've done nothing wrong? Or do I need to, just ignore? I was literally thinking about that because, because my company was small, medium enterprise, so maybe they would just get away with us. That was a stupid feeling, and also maybe I was thinking about forming an alliance with the, list of the other respondents as well. Internet search. Back then, I didn't have ChatGPT, so I had a limited information on the internet. Because obviously ITC were against to complaint were made against to a lot of big companies and corporations. Actually, funny enough, as a last resort, I spoke to back then the name was Kotra IP Desk, now it's KOIPA, and I spoke to them, and I got a referral of the one attorney sitting right here, John Kim. I ended up attaining him. And after that, the process started. So next slide, please. To fellow business owners, because I'm not a lawyer or legal expert, I wanna, really give piece of my advice to fellow business people from my personal experience perspective. When you are running business, doing so well, like COVID situations, selling a ton of the products, keeping yourself tight and together is really difficult. You have a ton of customers asking your products, and then, rumors are spreading fast. The couple of customers already know. They're telling you, like, oh, Sean, I heard about my Schenker is under ITC investigation. You all right? Can we still buy from you? Are we safe? That sort of questions are being asked, and you literally don't know what to say. And so setting up the defense strategies to continue your business operation under ITC investigation, I think is important. Of course, it's mentally difficult as a business owner's perspective, but you need to set up your defense strategies for the marketing and sales of your product. You need to continue to generate your cash flow out of the product selling. And also, I think another important thing is patent attorney. I think there are expensive one or experienced one for the ITC cases. I actually, before I contacted John, I spoke to many different lawyers as well. But here's my piece of advice. I think, no matter whether it is less expensive or more expensive one, I think you need to find the one compatible to you. I think finding your lawyer is like a marriage. And you need to find someone suitable for you, understand you, your feeling. Actually, lawyers are becoming your therapist as well. Like, you are under such a stress, and you need to talk to someone. Even your wife cannot say much about the case. So you need to talk to someone. And John was excellent in terms of that perspective, and I got a lot of relief from him. But I think it's the game of finding the right person for you. So that's my advice. And alliance. I think because on my case, there was about 10 to 15 companies. So I was actually thinking about it seriously. Maybe I can talk to them and maybe form an alliance to defend together. But actually, I spoke to John as well, and I ended up not doing that. Why? Because actually there were a couple of Chinese companies, competitors for us. I know lawyers and client privilege, confidentialities and everything. But at the end of the day, if I face the reality, sometimes email can slip out, mistake can happen. What if lawyers or Chinese clients maybe share certain information should not to. So I was actually worried about that because I'm also a product engineer and developing products as well. So I didn't want to share any product knowledge to them. So I didn't go for the route. But it could be working out for some other people. Arbitrations. I think this was the best solution for me. Worked out. I spoke to John and we did build the tactics of that anyway. But I thought maybe we can build strategies. A couple of companies are Chinese companies. They are lowering the market pricings and destroying the market right now. So maybe we can talk to the companies making complaints. How about we fight for you, fight together, and we can defend your products, and also we can represent your product in the United States as well. So I met them in person in San Diego. And it actually worked out really well. We hit it off, and then we became their sellers. And now we represent their products, and we still selling their product as of today. So again, this is maybe a solution for us, maybe not for the others. It could work out as well. The last one, the patent for your defense. Maybe this is also was my silly thought process, but I thought maybe because companies making complaint had about 7 patents under them, so maybe I need to file a patent for myself, and I began to do that. But actually, that was a little wrong decision, I think, because obviously filing patent takes about 3 to number of years, and depends on the patent anyway. But it's too late to fight with that patent once it is approved, because as Mr. Park said, ITC is a very expedited process. So I think it could be maybe working out for your future defense, but not right now. So I don't want to continue too much. So to the fellow business people, I want to really say one thing. Keeping yourself together in the middle of ITC investigation was really difficult. So I think it's the game of keeping your mental stress stable and firm and tight is important. And you need to have a good attorney to work together, and you need to talk to someone about the case. Again, maybe not the confidential matter, but I think you need to get some consolation from someone to be able to keep yourself together. Because I saw many business people make wrong decisions out of the patent litigations or ITC case, as I did as well. They have a mental breakdown and so much stress. They occupied by it, and their business operations go under. And I know. Now, after getting through this, maybe next time if this is happening again, maybe I'll do better. But I hope not. I think, as most stats are saying as well, it's happening for small medium enterprise as well. So I think it's good. I think at the end of the day, it's ultimately to business owners to decide the right decisions, and to be able to do that, you need to be in the right state. And also another piece of advice is. I've seen a lot of business owners relying external counsels or their employees to handle everything. That's wrong decisions. You gotta be the semi-expert. You need to know the terminology. You need to know the deadline. You need to know everything. then you are able to talk to your lawyer, talk to your other people. So you need to know about the patent. You need to know about the legal, the terms and knowledge. So don't rely on other people for everything. And I think if you are under any stress or suffering from this, patents or ITC litigations, I'm willing to help. I'm not charging anything, free of charge. Send me an email. I'll help you. All right. Thank you.
Thank you very much for that. For the record, I just want to clarify that all the therapy sessions that we had together, I didn't bill a dime. So, and Mr. Young's case is very unique. Typically, when you get involved with ITC, you get if you want to settle with the complainant, then you will agree to basically you're a much smaller company sometimes. And in this case, we had a larger company on the other side with a smaller company on our side. And the balance of power and the settlement negotiation is not in your favor. But in this case, we were able to work out a very favorable settlement that helped his company to continue the sale of the products and at the same time build a partner in the industry. So thank you very much for sharing that story with us. Next we have Mr. Arvind Iyengar, and he's a senior legal counsel for Samsung Electronics. He oversees IP disputes and he's here to provide his in-house perspective.
Yeah, thanks for that. So as far as the perspective from in-house, what I was trying to do, or I'm going to try to speak to today, is sort of less this strategy of, or the meat and bone and potatoes of an ITC investigation, but more, well, if you're in-house counsel or if you're a business person who's been faced with an ITC investigation, what are the things that you need to be aware of and considering, and how should you think about things in order to best help your outside counsel help you succeed in getting through that case, whether you're complainant or respondent. And so structurally, I thought we would do that by contrasting the ITC with a more standard district court patent case. And sort of I discuss why an ITC case you may need to approach it a little bit differently, or think about it a little bit differently compared to how you might approach a more standard district court case. So we can get the first slide, please. So first I want to talk about sort of the structural aspects that are different in an ITC case versus a district court case, and how that might impact your approach, your thinking, your strategy. The first and most obvious, you've heard from I think most of the speakers today, difference between an ITC case and district court is that ITC moves very, very quickly, whereas a district court case can take 2, 3, 4, 5 years. The ITC has a statutory mandate to complete their investigation within 18 months. So beyond just answering the complaint quickly, at every stage, the ITC moves incredibly fast. And some of that your outside counsel can handle. They're going to be responding to motions. They're going to be doing the back and forth directly with the opposing party, with the court. But as the company involved in the case, as the in-house counsel or as the business unit, you also need to be prepared to move very quickly. The place that for me this is felt most acutely is in discovery, especially early phases of discovery, when you're still investigating the allegations that were made, where you're still figuring out what documents need to be produced, what key individuals have the information that's necessary. If you're accustomed to district court practice, you can go through a longer process, right? You can talk to people, you can have time to speak to your managers, have them speak to the knowledgeable people on their teams, and then have that information filter back up to you, convey it out to counsel, they can ask follow-up questions, and you can repeat that. At the ITC, if you follow that same practice, you're gonna be behind. It's gonna take too long. And so you need to develop expedited approaches to gaining the information that you need from your team. And one way you can do that is by going directly, having whoever it is that's on the business side, whether it be in-house counsel, or if you're just, if you don't have your in-house counsel, someone on the business side who's involved in the litigation, managing the litigation, go directly to knowledgeable team members and find that information. Or if you don't feel that you have sufficient familiarity with the ITC to go do that, one approach I've seen other companies do relatively successfully is invite outside counsel to your office very early in the case and work with them in your office to go find the people who have knowledge to go figure out where the key information is stored. And once you have that once you and your outside counsel have that knowledge, it's much easier to go back and find the specific documents to make sure that things are collected appropriately and that they're transmitted to your outside counsel appropriately. One wrinkle in the cross-border nature of ITC work that you may not encounter in purely domestic disputes is often, especially with Korea, there are document export restrictions that you have to work around. And those take a lot of time. There are ways to expedite it, but ultimately it does take extra time to navigate. And to get that process done, you need to know what documents you want to export for discovery, which you're required to do. You need to identify them early. So getting boots on the ground, getting things moving, helping your outside counsel move as quickly as you can is something you really just have to do to avoid getting into discovery disputes and discovery trouble down the line in an ITC case. But really the difference isn't just speed of the ITC. There's also obviously different elements of both claims and defenses that impact how you as in-house counsel or as the business unit approach an ITC case. For me, the first one of those that comes to mind when you look at sort of a patent case is that importation as a requirement, right? A complaint to the ITC has to show that the product at issue is being imported into the US. For me, when I used to work in district court cases, that's not a concept you have to worry about there. And on the in-house side, often those are business units. The supply chain aspect of an importation discovery case is something that isn't often brought up in litigation. It's not often that I have to go to, the team that's involved with signing customs forms or with negotiating which dock a set of products is going to come into. Those teams and their documentation doesn't tend to come up in a district court case. But if you're not stipulating importation, in an ITC case, it's almost certainly going to come up. And so that means there's a business you may not otherwise have thought of that you will likely need to reach out to, find out where the information is stored and how it's stored, and potentially even talk to business partners in your supply chain who may help you facilitate the process of bringing a product in from overseas into the US to make sure that you have your ducks in a row and you can provide the necessary discovery on importation. Whereas it's something you may not have otherwise considered. A different factor, kind of statutory structural factor that you may need to consider is the domestic industry requirement. This is more so if you're thinking about bringing an ITC case than if you're responding to one. As we discussed, the ITC is not really a venue for quote unquote American businesses to sue international businesses. While it's sort of often colloquially thought of that way, any business that has a domestic industry in the US, whether you're headquartered in Seoul, in Korea, or in the US, can bring an ITC investigation. Now, the thing about that is, very often, especially the business side, tends to think of asserting a patent as you take your time, you consider whether or not you want to bring a patent suit, but once you decide to do that, you say, go file. And the attorneys go, they file a complaint, you hit the ground running. That's not really the way you can do things at the ITC. Because of the domestic industry requirement, you as the complainant have a factual obligation, a factual showing you have to make at the outset, right? To say, we are entitled to be here to take advantage of this forum because we have this domestic industry. And so it's important for me as in-house counsel or for a business unit, the counterparts that I work with, to understand and appreciate that there's more to an ITC case than simply saying, we want to file this case. We have a patent, we want to assert it. There's a factual investigation that needs to be done. We need to put together our own domestic industry case, and then we can file a complaint. And so there is a lag time between, decision makers making a decision on an ITC investigation and actually being able to say, we have filed, we have served it, the complainants are responding. It adds a little more time into that process on the front end. And that's something you should be doing and thinking about well before your complaint's drafted, before you're expecting to have that filing on the docket, because you have arguably as much time as you want until you file the complaint. And then things get going very fast. And if your domestic industry case isn't ready to go day one, it's very hard to get extra time, to get leniency from the ITC and say, we need more time to put together our documents, because you were supposed to have it already. Those are your documents, you should know them. As the ITC will say, they're not going to give you a lot of leeway. So you need to prepare that in advance and be prepared to spend some time in advance to do that. And then it's not on the slide, but one thing that Judge Rader mentioned that is interesting about the ITC is he mentioned, referring to his cell phone, that it also can be a healthcare device, which reminded me of the ITC, or one of the considerations the ITC does is what they call the public interest. Because the ITC is investigating on behalf of the American public, if they find a violation of a patent, they have the charge to consider whether issuing remedies, an exclusion order or a cease and desist order, would be in the interest of the American public. And so both sides can make an argument that the order would or would not be in the interest of the American public. And often it's tempting to think that argument is based on publicly available facts, information that's in your marketing materials, that's in how your product operates. There's not a lot on the in-house side you really need to do with that. Your outside counsel mostly has the information they need, which can be true, you can do it that way. But more effectively, you know the good stories about your product and your company, right? This is an opportunity to talk about, at the ITC, the good work that, especially if you're a respondent, that you, your product, your company do for the American people in the American markets, right? And if you have that ability, find those good stories. Go find the people on your team, especially if they work with the public sector in any way, if they work with outreach, if they work with disadvantaged communities, find those people and make sure their stories are collected and conveyed to outside counsel. Because it's an opportunity to really talk about how great you are, how great your company is. And it's not something that otherwise, I'm about to talk about, the ITC doesn't tend to care as much about sort of good guy, bad guy stories as district court may. But the public interest factor is one area in which you can tell those good guy narratives about yourself, and you should take advantage of that. But anyway, outside of the structural aspect of the ITC, if we can get the next slide, there are some less structural things, more ways of thinking that I wanted to address as in-house that in an ITC case are a little bit different from a district court case. And the first of those is sort of how you approach the case, what kind of themes you may convey. In district court, it's very common, as I was just saying, to sort of aim at good guy, bad guy narratives. Sort of, as a complainant, you may say, they stole our technology, we invented it, and they stole it. As a defendant, you may instead say, no, they're just looking for a quick buck. We are the true innovators, and they're just looking for $1, right? You tell these stories about who's good, who's bad, who's right, who's wrong, because you're talking to a jury, and the jury may not understand the nuance of semiconductor design, but they can understand they stole my idea. They can understand we're innovators just trying to help sell a product, right? And so you kind of craft your themes in those ways. In the ITC, because you're in front of an administrative law judge who spends every day dealing with patent disputes, who in many cases are either former patent lawyers or former engineers and technical experts, they are able to and are more inclined to delve into the nuance of the case from day one. And they want to hear more about what is the scope of this patent intended to be when it was invented, what does your product do or not do. The real nitty-gritty of invalidity, non-infringement tend to be more important to your themes. Your themes should focus more there than sort of who's right and who's wrong, as you might do in a district court case. And that kind of, in fact, impacts the entirety of how you approach an ITC case, all the way up through the hearing itself, where there's a temptation, because it looks the same, to think of an ITC hearing and a district court trial as the same thing, right? You go through discovery, you prepare all your witnesses, you do your preliminary motions, some evidence is in, some evidence is out, and then you go to trial. And it's the same in both, but the purpose of that hearing, of that in-person argument, is very different in the ITC than at trial, the district court. At the district court, you're going to go argue either in front of a judge or more often in front of a jury, and as soon as you sit down for closing arguments, they're going to go deliberate and issue a decision. This is what happens. At the ITC, that's just one step in a longer process. And so the ALJs are more looking for, get your information in, build your record, tell us what we need to know, right? So the focus on, in a district court practice, you may focus a lot on openings and closings to tell your narrative. In an ITC practice, because the focus is on building a record, there's a lot more focus on precisely what documents, and how are they getting into the case, how are they related to each other, and the precise language that's being used by witnesses and by experts, right? The goal of most of our ALJs at the ITC during a hearing is to evaluate the credibility of your documents and witnesses through the presentation of them, right? Which the jury is also doing. But the ALJ, many ALJs don't necessarily need to absorb or retain information in the same way because they have the record to look back at after the hearing is over. They can go find the facts if they need the facts. What they need to know is the information I'm getting credible and should I rely on it? And so specific, you can go back to your depositions, your past statements, and especially when talking, when examining experts, get specific admissions or statements that are beneficial to you. And so as in-house, as outside counsel, your outside counsel is going to do a lot of that strategy work for you, but it does impact sort of how your witnesses, how your employees should be expecting to prepare themselves, sort of what the focuses should be, and how the strategy of that hearing is going to be different. If you hear your outside counsel not talking very much about what's important in the close, about the story they're telling in the opening, there's a reason for that, right? And you should expect that they will do that a little bit differently at the ITC than they might at district court. And then finally, a big difference that is often underappreciated is that at the ITC, as I kind of alluded to earlier, there is a post-trial phase before you get your first judgment verdict. And the ITC is called an initial determination, which is after the hearing is done and all the evidence has been admitted, the record is closed, but both parties get to do written briefing as to what happened at the hearing and what that means as far as your claims or defenses. And we're talking about like hundreds of pages, both back and forth, where you'll get to be heard on what invalidity evidence was presented, why does it argue invalidity? What infringement evidence was presented, why does it argue infringement? Back and forth. And it varies from ALJ to ALJ, but generally speaking, the ALJs are going to rely on those briefing papers and the paper record, transcript, of what happened at the hearing when making their judgment, and much less so on their notes and recollection of what happened live. And so it is less important at the ITC that your trial team put on a good show and look really impressive at the hearing. It's always good. It's always good to come across impressive and polished, don't get me wrong. But that's less important at the ITC than getting the record you need so that at briefing, you can point the judge at, these are the 3 key pieces of evidence that show we won this case. And it's the briefing that usually is going to dictate who wins and loses an ITC investigation. That's just kind of the way things go. So with that, I think if you are coming from the perspective of having a general idea of how district court cases work, you consider these simple differences in both approach and mindset, I think you can be ready, with the advice of your outside counsel, to defend yourself against an ITC case despite the speed and sort of fear that it can create.
Thank you for that. Does the audience have any questions for Mr. Iyengar? As an attorney representing a very large multinational company, what would you say was your biggest challenge, both internally and externally, that you faced in managing 337, cases?
I think for me, the biggest challenge, and a little bit of background is probably useful, and I came from a background of working in law firms with much smaller clients, where if I talked to someone in the GC's office, they knew every aspect of what their business did and how it operated. And then when I came to Samsung, it's almost impossible for anyone to know every aspect, any single person to know every aspect of what Samsung does. And the people who have that level of knowledge are way too busy to spend time on any given patent case. So for me, it was becoming an expert in the company itself is an endless task. It's something I've done in my time at Samsung so far, and I'm still working on doing, but always being open to finding out new aspects of the business that I hadn't appreciated before, investigating them, and making sure that when outside counsel specifically, but even less information about my company than I do, ask, do you guys have this? Do you guys know that? Do you do this? My answer can't just be off the cuff, yes, no, whatever, based on my past knowledge. Every time I do that, I have to go back and verify, because it may be that a subdivision of the company has spun up a new project, or a subdivision that used to exist got spun off or shut down or changed focus in between my cases. And they don't always report that information back up, right? Like the IP group at Samsung doesn't get a report on what every single other group is doing. So it's a process of constant investigation, of constantly keeping up to date on the operations internally, so that when I'm talking to outside counsel, I can give them the best information.
And for outside counsel practices in the ITC cases, what are some factors that you and your in-house colleagues take into consideration in selecting outside counsel to run ITC investigations?
Sure. I mean, I think you'll be unsurprised to hear some of them, right? Obviously, cost is a factor, experience in the ITC, experience in our technology area, or the technology area of the case, are going to be the big three, and I think any client would expect those to be the big three. But beyond those, I think the next thing that I'm looking for is keeping certainly myself or my colleagues in the IP group appraised of what's happening, making sure that we're partners in defending or prosecuting the ITC case. It can be very tempting, and a lot of clients prefer this. Some clients prefer it, that to let your outside counsel, once you hand them a complaint, run the show, and they just, they will take on the burden, so you don't have to. They will defend you to the best of their ability. They're the experts. All of that's true. But at a company like Samsung, we have a lot of people internally who have lots of experience in the ITC. I used to be an ITC practitioner myself before I went in-house, as did a lot of my colleagues. And we have an expectation that we know what strategic decisions you're making, why you're making them, and that you have input from people who, we may not be as experienced in the ITC as our outside counsel. Hopefully we're not. But we have more experience with Samsung. We have experience with Samsung's past ITC cases, what's worked and hasn't worked for us before. And so keeping us appraised so that we can keep you appraised is a key part for me of what makes outside counsel great rather than just really good.
Thank you, Rick, for that. Next, I'm very thrilled to have Ms. Morgan McPherson on the panel. She's an attorney advisor with the U.S. Customs and Border Protection, and she'll talk to us about CBP and various programs that's available at CBP for protecting, and enforcing IP rights.
Thank you so much for that, and thank you for having me here today. Once again, I'm Morgan McPherson, and I'm an attorney advisor at U.S. Customs and Border Protection in the Office of Trade, Office of Regulations and Rulings, in the Intellectual Property Enforcement Branch in DC. Next slide, please. First off, just a quick question for y'all. How many of you have received a seizure notice from Customs and Border Protection? Has anyone here? All right. Well, I'm glad that I'm here today, just to get this engagement going. So you might ask, and this has been alluded to a little bit with our first co-panelist, Mr. Park, mentioning the kind of partner-government agency relationship between ITC, or International Trade Commission, and U.S. Customs and Border Protection. So you might ask, what is CBP's interest in IP protection at the U.S. border? So CBP has various enduring mission priorities, and intellectual property protection falls under the facilitation of lawful trade and protection of revenue. Okay, next slide, please. So just going to what is CBP. When I say CBP, that's short for U.S. Customs and Border Protection. What is our IP border enforcement structure and authority? Like, where does it come from? So CBP is the primary federal agency for responsible for securing U.S. borders. CBP is America's front line in safeguarding the American public from illicit trade. So the enforcement of IP rights, it is a civil enforcement authority. There is criminal action possible, but primarily the civil enforcement comes from Title 19 of the Code of Federal Regulations under federal law. And that's where all the customs authorities are. And CBP has what's called broad ex officio authority. So this means by the authority of one's official position or job. So this means that in CBP, we have this really broad authority to enforce intellectual property all the way from the cargo inspectors at the border, up in the office in the OFO, Office of Field Operations, CBP, all the way up to the reviewers at the attorney level, like myself, who were reviewing as whether there's probable cause to seize on the basis of IP infringement. So CBP has this authority to detain or suspend release of suspected infringing goods being imported to the United States, as well as seizing without the right holder, so the owner of intellectual property right, coming to us for each infringement action as per each importation. Instead, we focus our enforcement efforts on what is called recorded intellectual property. So as a right holder, IP right owner, you have the opportunity to record a federally registered trademark or copyright with U.S. Customs Border Protection for enforcement at the border. And this is an administrative process. So if you are an importer and you receive a seizure notice from CBP, you have multiple opportunities to challenge the seizure of your goods. There's multiple layers of review, and right holders are not charged for the enforcement procedure. However, I will, in future slides, discuss about the minimal cost and, in our opinion, minimal effort and recording with CBP to protect our IP. Okay, next slide, please. So, as I alluded to before, CBP has this broad authority to enforce trademarks and copyrights at the U.S. border. To that end, we also we will enforce utility patents, design patents, and trade secrets, but in regard to those three types of intellectual property, CBP is only able to enforce those pursuant to an ITC exclusion order. So, as a patent owner, trade secret owner, you'll have to go proactively to the International Trade Commission and apply for and receive either a general exclusion order, or GEO, or limited exclusion order, LEO, for which CBP to enforce. So at this time, CBP, we have a few hundred exclusion orders that we enforce at the border, whereas right now we have around 20,000 recorded trademarks and copyrights that we enforce at the border. So I am offering to you all and for your clients as an additional way to protect against importations that may be infringing your intellectual property, to also consider recording your trademarks for copyrights. So if you're an owner of, say, a patent, I presume you also have a marketing department, and you will have a logo or a brand name, and you may choose to register with U.S. Patent and Trademark Office. Next slide, please. Yes, so you may say you may choose to register your trademark with USPTO, and once you have that registration, you can record with CBP that trademark, so you can enforce it at the border as it appears on your product, say the packaging in which your patented product is imported. As well as you can also record your copyright, that once you have a federally registered copyright with the U.S. Copyright Office, you can also come to CBP and record with us that copyright. And once again, in the context of a patented good, say a pharmaceutical drug, it may be packaged in a rectangular carton, and you can actually, as you probably know, register that copyright for the packaging as it appears, and then you can also record that copyright with CBP. So to be able to enforce your trademarks or copyrights with CBP, it is that two-step process. First, once again, you have to have that federal registration with Patent and Trademark Office or Copyright Office before coming to us. You submit an application through IPRR. It's iprr.cbp.dhs.gov, and I'm happy to provide you these links later. And it's a really quick process. It takes about 30 minutes to apply. And for a trademark, for a federally registered trademark, it is $190 US per international class to record with CBP, and you receive 10 years of protection at the border, concurrent with the underlying patent trademark registration. So that still has to be a valid registration on the principal register with the USPTO. Alternatively, with copyright, when you register or when you have a registered copyright and you come to record a CBP, that is $190 for copyright recordation, and that is for 20 years of protection at the US border, concurrent with the underlying copyright registration as well. And so once again, for the applicant, this can be either a paralegal, it could be the right holder themselves or agent thereof. It takes only about 30 minutes to file online, very easy process. We have a great paralegal team. My team, the IP enforcement branch at USCBP, we're about a dozen attorneys, 2 paralegals. We process the applications very quickly, within 24 hours. We have a team of attorney reviewers, of which I am one, and we manage this database. Once we confirm that you passed our recordation process, we will notify you, and it will be stored in our IPRIS, IP Recordation Internal System database, which all of our CBP officers at all 328 US ports of entry have access to online. That's the internal facing one. And we recommend that you provide to us any information that is helpful for CBP to better enforce your intellectual property. So that might be a product ID guide, specimens of how your copyright or trademark appears on authentic merchandise, authorized licensees list, very up-to-date points of contact, all that information. And then of course we also have IPRS, which is the external facing version of our database of all the recorded trademarks and copyrights. And of course, all the information on there, it is protected and under the Trade Secrets Protection Act, there is no proprietary information that's going to be displayed, reviewed to the general public. Everything is protected. Next slide, please. As a recordation holder, so once you've applied and received recordation status with CBP, you have this opportunity to submit to us additional authentication guides or manuals, set up trainings, either virtually or in person at US ports of entry. Also, there's e-allegation reporting. That's actually open to everyone in the public. I can provide that link as well. So that's if you have knowledge or suspected knowledge of an infringing importation, any identifying information about that shipment you can provide to CBP, and depending on leads, we will do everything we can to pursue that. And also just generally enhance partnership with CBP. My main recommendation, and as has been discussed before, is really being knowledgeable about your product or your client's product, and just having enhanced communication with CBP to continue best practices of enforcement of your IP, and really just increase collaboration and good communication. And next slide, I think that might be it. Yes, any questions? Sit back down.
So if your product is being seized at the border because of the trademark or any infringement, is there any way, maybe talk to the right owners and settle license agreements and release at the border after that, or does product need to go back to Korea and import again? Like, is there any way to mitigate in the middle?
That is a good Is this back on? Yes. That is a great question. Thank you so much. So what you're discussing would be a private right of action. And that would be a business decision that the right holder and the importer could make. But that said, once again, we really recommend that the right holder be recorded or to pursue getting those exclusion orders with the ITC so we can enforce your intellectual property. But yes, the choice to pursue a license agreement, that is outside the purview of CBP. However, as I mentioned earlier, it is really helpful to us if you do have licensees of your intellectual property, if you're recorded trademarks or copyrights. Once again, I'm speaking in regard to the CBP IPRIS recordation database. It is very helpful if you keep us up to date and provide us updated lists of your licensees, so we can be appraised of who is authorized to import your goods. Thank you.
First of all, I wanted to say this is a very good presentation. Thank you. I learned something new. My question is, if there is a copyrighted digital material and somebody is importing it into the United States, is there any way you can protect the copyright holder, or you can only do it for things that are physical?
That is such a great question. Thank you so much. So yes, CBP, we focus our enforcement efforts in regard to IP on hard or tangible goods. However, we do enforce copyrights pursuant to DMCA, or Digital Millennium Copyright Act. But this is in regard to software that is inside, right, I guess that's what I'm saying, downloaded within a physical product that's being imported already. But yes, you can we have many copyrights that are, say like video games or some software, but as they appear within it, recorded on a tangible medium that is being imported into the United States.
What if it's just coming online?
Oh.
What if it's coming online?
Yes.
Is there any way to help the copyright holders in situations like that?
Yes, once again, great question. That is outside the purview of CBP, but potentially that could be something within HSI, sister agency, Homeland Security Investigations, within DHS, Department of Homeland Security. So if you're familiar with the IPR Center, which also sits in Northern Virginia, and that is a collaboration of several law enforcement agencies that have a vested interest in enforcing intellectual property. So that could be an avenue for sure, and we can connect and discuss about how to get you in touch with the IPR Center for investigations like that. Thank you.
Thank you for that. Next, we only have a couple of minutes left, so I'm going to just go through IP litigations very quickly. Sorry. One more question. Okay, go ahead.
Oh, hi, I'm Mike Franzinger. I'm an ITC litigator at Denton's. As some of you know, there have been several ITC trade secret cases, which were one Korean company against another. And I think in one of them, it was about Botox, and there was like an agency of the Korean government that was somehow stopping the discovery that needed to happen for the case, and the case actually got stayed for a long time while that was figured out. Is that something that's common? Does that happen in other cases, or is that really just unique to that one case?
Yeah, so I've worked on a couple of cases where a Korean government agency called MOTI gets involved, and they control, as Arvin already mentioned, they control export of information that relate to national core technology, right? And they have really strict control over that, especially in view of all the trade secret sort of theft and leakages that have happened in recent years. So the investigation that I worked on recently, 1313, we were slowed down quite significantly over a year, I believe. So I think, we'll see how MOTI conducts itself after this, because the delay was quite significant. But in in even previous ITC investigations involving other large Korean entities, there were some delays, but it was not as significant. The biggest delay was in the latest ITC case that I worked on. So how it changes over the year from now on is to be seen.
One thing I will add to that, because obviously we've dealt with MOTI a number of times in our cases, is that because the ITC has a statutory obligation to complete their investigation within a certain time frame, you can certainly, the ALJS will work with Korean entities to get to delay discovery, allow time for document production to occur. But there have been suggestions, although I haven't seen an order come down yet, to this effect. Certainly mostly suggestions from complainants, but ALJS seems potentially receptive to it, that getting those documents, if the documents aren't available, then there may be adverse inferences, or simply you don't have the information you need to defend yourself. The case is going to go forward without that information. So it is a concern that needs to be taken very seriously. The ITC is unlikely to just wait indefinitely for MOTI clearance. While they're not going to overturn, obviously, an agency of the Korean government, they can move their investigation forward without that if they deem it necessary.
One more point. So the investigations that I worked on involved Korean parties, so both the respondent and the complainant were Korean. So in that case, discovery is delayed by both parties, in which case the parties basically didn't have nothing to really complain about as, regarding the opposing party, right? So I guess the situation will be different if only one of the parties is Korean and the other side is not. And if all this delay happens, then I think the balance is going to be different. So in those cases, like Arjun mentioned, there could be some negative implications.
Okay, no more questions? Okay, so we're running over time here, so I'll just quickly go through IP litigations. There's a speaker after this regarding IP litigation, so we'll skip through the first slide. And as many of you know, litigation is lasts a long time and it costs a lot of money. There's some survey. Next slide, please. So there's a survey done by AIPLA 2023, listing the attorney fees or the cost for litigating patent cases at the district court. And there, for cases involving $25 million at risk is over $6 million. And generally speaking, as a defendant in a litigation, it's very difficult to challenge the validity of patents. So if you are a defendant and if you're going to win, then your chances of success will be best if you can have a good non-infringement argument. And that's because the patents are presumed to be valid, and to invalidate patents you have to do by clear and convincing evidence, which is very difficult to do. Next slide, please. So there are different alternatives of challenging patent validity, and one is at the USPTO, IPR and PGR, and basically the whole, if your proceeding gets implemented or instituted, then it will, from the time that you file your petition to the final decision by the USPTO, everything gets decided in less than 18 months. And the cost-wise is a lot cheaper. It's about $350,000 according to AIPLA through hearing for mechanical and electrical patents. Chemical and biological inventions or patents, cost a little bit more, but that's still a lot lower than what it would cost in a federal district court. And the chances of success is very, very high. According to the USPTO statistics, 71% invalidity rate for the first 2 quarters of fiscal year 2024. It was 61.8% at 2023. So you have, if as a challenger of a patent validity, I'd rather be before the USPTO patent judges than jury or a district court judge in litigation. And also, if you're successful, depending on what jurisdiction you're in, you may be able to have your related district court case stayed.
So these are some advantages for, I'm sorry. Another alternative for challenging patent validity is, next slide, is that? Is that the next slide, please? Okay, re-exam. Is that you file re-examination ex parte, and once the re-examination is instituted, then it's between the patent office and the patent owner. And as a challenger, you're basically on the sidelines. So it's not really popular way of challenging patent validity, but there are a lot, some benefits of that is that it's very inexpensive, cost-effective to file re-examination at the patent office as a challenger, and in non-litigation settings, it may offer a cost-effective way of challenging patent validity at the patent office. Thank you very much for your participation on this panel. I really enjoyed presenting this panel with you, and thank you for the questions that was presented by the audience. Thank you.
Hear me now?
Thank you very much.
Great. Tommy Martin from Baker Box. I'm pleased to be here to speak to you today about recent trends in IP litigation. Starting with the trends in filings, I've covered trademarks, copyrights, and patents here. As you can see, patent filings, they dropped in 2018, 2019, they've made a return. Showed a little bit of drop last year, but we're predicted to be at about post-2019 levels this year. Trademark filings have been pretty steady across the board and are expected to be about the same. The one that's notable here is copyrights. The copyright filings have increased, excuse me, tremendously. And so what I've done from this slide and throughout the presentation is try to tie that to something that happened. So what I believe started the trend in the increase in copyright infringement cases is AI. And this is the case this is what is known to be the first case in which AI was issued. It was filed in 2020, and the number of copyright cases has just increased since then. This particular case is the company that owns Westlaw sued this company, Ross, for using Westlaw materials to train their AI. I believe Judge Rader was mentioning how long district court cases take. This case is still going on, but it has survived summary judgment. So the issue is real, and so it's a good weather, or a fair weather marker for what we can probably expect to see a lot more AI type copyright filings. This slide is on the most active patent venues. No surprise, Eastern District of Texas, Delaware, Western District of Texas, as Judge Rader mentioned. They're not heeding his advice. A lot of these, as you'll see in later slides, are non-practicing entities, or what people refer to as patent trolls. These are some of the favorite venues there. Delaware is a favorite venue just because so many companies are incorporated there due to their tax laws and things of that nature. Texas is very popular because their juries are known to be very, very patent friendly. So you can see ED Texas has been at the top of the list. Delaware is pretty steady. The Western District of Texas made a huge jump when Judge Albright took the bench. He made it his mission to make it as popular a venue as Eastern District of Texas, and was successful at doing that for a time until the chief judge in his division, the Waco division, decided to create a spinning wheel system which randomized which judges were assigned cases, so you were no longer guaranteed to get Judge Albright if you filed in the Waco division of the Western District. And you can see a decline there. So you can see a lot of the filings are dictated based on how favorable, as Judge Rader alluded to, people always want to know the most favorable place to file. And people still view these as the most favorable, but in Texas, Western District, you're no longer guaranteed to get one of the most rights holder, patent owner friendly judges. Turning to the most active trademark venues, Northern District of Illinois, Central District of California, Southern District of Florida. The most notable thing here, it's all pretty consistent as we saw on the first slide, but Northern District of Illinois has seen an incredible increase in trademark filings. And we believe that's likely because of what's called a Schedule A case. We're seeing a lot more of those, and I'll talk about those after the next slide. Turning to the most active copyright venues, slight increase in copyright filings. Again, that trend follows the first slide I showed you. But again, Northern District of Illinois stands out here as having a large number of new filings. So this is one of the new trends I'd like to talk about, these Schedule A litigations. What's a Schedule A litigation? It is a litigation where a patent owner or IP rights holder, in fact, most of these are trademark cases. There are patent cases, there are copyright cases, but you sue a large number of infringers at one time, seeking a temporary restraining order, which I think the average is like 14 days that you can get a temporary restraining order. And they're called Schedule A cases because you don't even identify the defendants in the public complaint. You put them in a confidential Schedule A or attachment to the complaint. They don't know that a temporary restraining order is issued against them until after it issues. So it's very quick, very powerful for the rights holder, very scary for the infringers because again, by the time they find out about it, it's too late. And they usually find out about it because their accounts are frozen on e-commerce platforms, which this is what one court says, this is what the Northern District of Illinois has said about these particular types of cases. They mention this whack-a-mole problem, which is the problem of you sue somebody, rather than fight it, they close their operations, they move their assets to some other company, start the new company, and just start the same process over again. Referred to as a whack-a-mole process. It is the Northern District of Illinois said because of this, they say it's become the Northern District of Illinois versus the internet. So a very big problem, and these cases have been shown to be a very effective way to battle it. And as you saw on those slides, there's a whole lot of these filings happening. So even foreign companies, even Chinese companies are suing Chinese companies for knocking off their products. So it's been very effective, very fast, and no coincidence in the increase. It's most effective against, as I mentioned, Amazon, Alibaba, Walmart online. And so you can literally see almost identical rise in these cases being filed, trending with the rise in popularity of e-commerce platforms. So Schedule A is a big new trend in IP litigation. This is just to show how absurd Northern District of Illinois' share of the cases is. They move kind of the quickest. They literally have templates for your temporary restraining order and your other orders. So they're almost showing you how to file these things there. The second biggest is Southern District of Florida, then Southern District of New York, and everyone else is a much smaller portion of these filings. So turning now to PTAB trends, they follow, there's been discussion of IPR's inter partes review at the Patent Trial and Appeals Board. It is a good defensive mechanism frequently used by defendants in U.S. litigations is to challenge the patents. At the PTAB, the standard of review is a little lower, and it usually results in a stay of the district court case, not the ITC as they mentioned. But for that reason, it largely trends the same as patent infringement litigations. And so you can see it's pretty linear. It dropped when patent infringement cases dropped in 2018-19, but it's largely been the same. There's two other forms to challenge post-grant patents. Those are CBM filings and PGR. They pale in comparison to, of course, the IPRs. And the only thing notable here in the trends is that the CBMs and PGRs flip-flopped in 18 and have stayed that way in terms of the volumes of filing. I showed before is one of the most popular venues. We think that there's a drop in Delaware because Judge Connolly has issued a new corporate disclosure statement requirement. He's getting tired of the non-practicing entities and their complicated corporate structures. So he's got a very much heightened requirement for your initial disclosures of who has an interest in the case. And this is what his standing rule is. You need to name every owner, member, or partner of the party proceeding up the chain until the name of every individual and corporation with a direct or indirect interest in the party has been identified. So that is a very extensive and steep requirement. And this is, I could spend the entire presentation talking about this, but I've got 3 slides on how he pieced this together and what made him, what made him put this rule in place. He had 3 cases going forth in front of him, and he was able to unpack and tie them all to this Max Vera company that he also tied to IP Edge, and this is just how tangled one case was. And you can see, certain attorneys are talking to certain people. He tied all the correspondence together and linked everyone together, and this company, of course, is incorporated in a packet mail at a Staples Center. He unpacks the fact that if you put together all the agreements that they produce, that more than 100% of the winnings are due to different parties should the patent case prevail. Some other interesting ones, but he's got these 3 cases. Again, I could spend the whole day talking about these, but there's crazy stuff in here. The owner of the main company runs a food truck and comes to court and doesn't know why he's there. So the judge effectively got tired of kind of seeing these companies use just regular citizens to incorporate companies to file these patent cases to shield themselves from any liability, mainly attorney's fees for filing frivolous lawsuits. So Judge Connolly has decreased the number of filings in his case by non-practicing entities by requiring them to disclose everyone behind it. And even in this one, you can see one of the guys in IP Edge has his wife owning one of the companies that's transferring patents to other people. So it's pretty complicated, pretty impressive that Judge Connolly unpacked it all. But as a result, you're seeing fewer filings in Delaware. And I think other judges are going to probably start to follow this pattern of requiring more disclosure. And I'll give you an example of judges getting tired of NPEs in another slide. Again, crazy percentages. So not only does Judge Connolly here have them recommend that they be looked into, investigated by their local bars, he asked the Department of Justice to look into these guys as potential criminals. So pretty steep punishment. This next one is most active patent firms. You can see on the plaintiff's side, it's Ramey and Rabekoff. If you're a patent litigator, you know these guys' names. I get an email every day with everything filed. I see their names every day. And you can see 871, 866 active cases. The defensive side is more big names that you've probably heard because they're defending all these people that are getting attacked by non-practicing entities. But pretty crazy numbers. And so this is the other slide I was talking about. This particular judge, who actually is a former partner of our firm, who I used to work with, realized that Mr. Ramey was currently litigating 53 cases on a pro hoc basis. He's a Texas attorney. He's in California, he's got 53 cases going, and he's made an appearance in 3 of them. Yet, you can see that he is driving the bulk of the litigation activity. And so, he's a very well-known patent troll NPE attorney, and he is sanctioned for the unauthorized practice of law in California. So, judges are clearly getting tired of these attorneys that are making these mass filings, not even bothering to support the court by paying the pro hoc fees and formally make an appearance. And so, again, the judges are definitely getting tired of the NPEs. Turning back to NPEs, these are the top districts for non-practicing entities. No surprise, it's the 3 that were in my first slide. We've got Western District of Texas, District of Delaware, and the Eastern District of Texas. The only notable trend here is likely because that Albright is not getting as many cases. Eastern District of Texas is now taking the lead for both filings in general and NPE filings. The last slide is maybe one of the most interesting developments this year. Is this one particular case, Loper Bright Enterprises versus Raimondo. This case decided that to reverse the long-standing Chevron deference standard. That standard said that agencies like the ITC and the PTAB, instead of the district courts, were no longer given deference to their interpretations of the statutes that governed their operations. And so the implications of this are the ITC. Induced infringement is probably subject to a challenge. There's the requirement, they mentioned the importation requirement earlier. The previous law as interpreted by the ITC was that you could contribute or induce infringement after infringement, right? The product didn't have to infringe as imported. That's likely going to be subject to challenge very soon, so that maybe only direct infringement is available at the ITC, which means, right, if your product is combined with some other part later, you could potentially avoid infringement, but we're hopeful, as I mentioned in the last the last bullet here, that the deference will still be given because the courts can have the discretion to do that. The next is domestic industry requirement. That was discussed before. That's likely subject to be challenged. That is one of the best ways people get out of these cases. You can be infringing, but if they can't prove they have a domestic industry, you can escape violation in an exclusion order, so that's likely to be challenged soon. The other is one of the provisions of 337 is that sale for importation is illegal. That's like the interpretation there is also likely to be subject to challenge. Moving on to the PTAB, the director has a memorandum on discretionary denials where they can just deny at their discretion applications for inter-parties review. That's just a memo. It is subject to challenge likely, and there's actually already a federal circuit case challenging the real parties of interest that's similar to the corporate disclosure statement I mentioned before. It's the PTAB's version of that. When you file an IPR and you want to review someone's patent and challenge its validity, you have to reveal who are the parties interested in validating the patent. And so that is likely to be challenged, and maybe it could even go the direction that Judge Connolly has gone, that all the way up the chain type requirement. But ultimately, as I just mentioned, federal courts still have the discretion, so those of us I practice at the ITC as well, and the PTAB frequently hopeful that the district courts will continue to give discretion to the courts, to the ITC, PTAB, and other federal agency decisions, as they are totally entitled to do. And so the hope is that they will just say this has been well reasoned and thought out and ruled upon by this body, and so I'm just going to adopt that. But again, they no longer have to. So that's an important development this year, and that was just in June. So that concludes my presentation. I know it was a lot of data in there. I'm not sure if the materials will be made available to you. If not, please feel free to email me. I'm happy to share them and answer any questions you might have.
Hello everyone, and thank you for this opportunity to present. My name is Yoonhee Kim, and I'm a partner at Finland LLP, working primarily on IP litigation and patent counseling matters. Before coming to America, I was a Korean patent attorney. In today's presentation, I'll be talking about IP litigation practice, specifically discovery in patent litigation, which I believe is an important topic to every company is interested in patent litigation. Quick disclaimer, this presentation is educational and informational purposes only and does not necessarily reflect an opinion of my firm. Now, without further ado, we will be covering litigation timeline and process discovery in this report and global IP litigation as time permit. So what is discovery? In US litigation, unlike any other countries, parties are entitled to discover evidence from the other parties. Discovery is the stage in litigation during which a party can request and obtain information and documents from the other party. This is a general timeline of US patent litigation. Take a look at the timing of discovery. After a complaint and answer have been filed, and prior to that is a so-called litigation hold, which involves a duty to preserve evidence and document. There are fact discovery and expert discovery, and we will be focusing on fact discovery in this presentation. This is a jurisdictional map of US District Court, including 3rd Circuit, 5th Circuit, and 9th Circuit, where Delaware District Court, Eastern District of Texas, and California District Court are located. These districts are where many patent infringement claims have been filed, and also against Korean companies. This is litigation timeline in recent years in this district. As you can see, it is typically 2.5 years through the trial. Here, discovery period starts typically after the answer was filed, and the end period depends on the case and jurisdiction, but it will be the longest stage throughout the process. This is governing rules of IP litigation. Every IP litigation. First is most important is federal rules of civil procedure. Second is local rules specific to the local. It could be Delaware, it could be Eastern District of Texas, or California District Court. But I believe Delaware does not have local patent rule, but they do have local rule. There is going to be judge's specific order, which is called as standing orders, and there is federal rules of evidence is also part of governing rule. And what is fact discovery? The goal is uncover fact necessary for the parties to litigate issues. There are two conditions to keep in mind: relevant information and non-privileged information. Relevance is broad, but not overly broad. And with privilege assertions, so-called attorney-client privilege and work product immunity, a party has the right to withhold certain information or document from discovery. And there are two methods to conduct fact discovery: the written discovery and deposition discovery. And here, tools of discovery: document request, interrogatory, request for admission, subpoenas are part of written discovery. And initial disclosure is next. Initial disclosure is the first step in any litigation. Without awaiting a discovery request, either document request or interrogatory, parties must provide voluntarily the list of people likely to have discoverable information, and this category of information or documents in their possession that a party may use to support its claims or defenses. The key word here is may use to support its claims or defenses. So as a patent owner, you have a patent infringement claim. So document relating to your invention and patent. As accused infringer, you must have document to support your defenses. It could be non-infringement, it could be license. So and you will need to identify those type of information in your initial disclosure. The first primary tool is document request. So for request for production of document. Under FRCP 34, Rule 34, both parties must produce any discoverable document in their possession, custody, or control. That needs to be relevant information, and in patent litigation, that typically includes invention, accused product, patent prosecution, R&D document, and business plans and records. Next, the second primary tool is interrogatory, so-called ROGs. It is governed by, the source of this tool is FRCP 33, Rule 33. It is a written question to be answered in writing under oath, and is effective way to obtain information on narratives that includes who, when, or where. It could be used to support, to ask information about infringement claims or any facts supporting affirmative defenses. Typically, in patent litigation, document requests are directed to invention, prosecution, research and development, prior art, marketing and sales, license agreement. Interrogatory requires, is typically directed to date of invention because U.S. patent law has different from Korean litigation. It's not just based on filing. So date of invention is still matters under AIA and more matters more in pre-AIA world. It is also directed to a person with knowledge to witness a specific event or narrative, damages and contentions. And interrogatory may ask for facts, contentions, legal theories, and witness identity. A bit less used is request for admission, but it's still used for tool. It is governed by Rule 36. It is a request to the opposing party to admit the truth of any discoverable matter. The response must admit, deny, object to each request, or otherwise explain in detail, and failure to properly respond may lead to admission of the fact. Now we'll be talking about document collection and production. Each party must preserve what it knows and should have known is relevant to the litigation. Good faith and reasonableness is the standard, but not perfection. The scope is to be described in litigation hold memo, circulated internally within the company, and there is going to be consequences for failure to do that. And when in doubt, don't throw it out, and just call an attorney if you're not sure about what to preserve and what to collect. And what is a document? Document is more than papers. It could be electronic file, emails, and some other types of document. Document collection and production. All relevant document requested by the opponent or helpful to the company to support their case, either claim or defense, needs to be collected and produced. Reasonable search is required, no need to be perfect. And those collected documents will be reviewed by attorneys, first responsive to each request, document request, and to be determined relevant and non-privileged document will be produced. As they are kept in the ordinary course of business, and there is also a duty to supplement. And typically, production are conducted on a rolling basis. You might ask, this is a highly confidential document, internal document, but that is not actually a justification for not producing document, because U.S. courts have a protective order in place. Protective order protect confidentiality of information, confidential document produced to the opponent that controls how confidential information is used, who can have access, how to be presented at trial or in a court paper. And it could have multiple tiers, and each tier will define who can access. But there is also exception to production obligation, which goes to the issue of privilege. Privilege is the right to withhold certain information from discovery. And there's two major sources of attorney-client privilege and the work product community. And the keyword here is those in red font. This is how typically the privileged information is withheld from production or redacted. In this example, there's meeting minutes and legal update portion has been redacted, and it will be produced as redacted, those portions, probably with the marking that privileged for redacted for privileged. But a privilege is not absolute. It may be waived. The protection goes to legal issues, but not business issues. Another example of proper communication with the attorney. The sender sends to the attorney only this email, and it is asking for legal advice. I found this patent, I think it covers something, and at the end, this sender is requesting legal advice from the attorney. As you can see, there's attorney limited distribution to attorney only. But please don't do it. This is example of the document that will end up in trial exhibit. Distribution is everyone, and even there appears to be not someone within the company. And it says, look at this patent, it covers something. And one takeaway is to avoid harmful statement. Don't write anything that might prejudice litigation if disclosed to the other side. Quickly, deposition is sworn testimony recorded by a court reporter. There's two types: individual capacity, fact witness, and there is corporate representative, so-called 30v6. Will be there attorney defending witness, attorney taking deposition, court reporter, videographer, and to Korean deponent, there is going to be interpreter. And typically 7 hours under oath, but a few more hours to be added because interpretation is involved. Quickly, expert discovery. Again, the goal is to develop expert testimony for use at trial. The qualification is a person with ordinary skill in the art that could be critical. And tools of expert discovery is expert report, initial, responsive, and remote. Credibility is key in expert preparation and discovery. Lastly, managing global IP litigation. Parties increasingly compete in the global marketplace, and dispute likely to have different jurisdictions. US, it could be US, it could be Europe, it could be Japan and Korea. And that requires careful coordination between counsel. So some of the considerations for global domain maintaining and managing global IP litigation is what is the most important market that litigation team should handle. Run the point that which happens to be US because credibility is important to the US court. And also argument and evidence in foreign proceedings are discoverable in the US case. And to keep in mind, there could be conflicting positions because there will be difference in law and procedure, and some of your characterization of either prior art or your own patent could matter in the US. This concludes the presentation. I'd be happy to take questions if there's any when the session is over. Thank you.
I'm working at IPTAB in Korea. Thank you for attending. I'd like to thank USPTO, PTEP, and Embassy of the Republic of Korea in the USA, and KOIPA U.S. Capital IP센터, KIPRO, PCT Center, PCT Korea Center. Today, I'm going to give you a brief introduction to the IPTAB. IPTAB is Korea Intellectual Property Trial and Appeal Board. I will talk about overview of IPTAB, statistics of patent trials, and recent institutional reforms. So now let me show you who we are and what we do at IPTAB. IPTAB consists of three parts: boards, trial policy division, and litigation division. There are 10 groups of boards with 101 IPTAB judges who review and hear trial and appeal cases of patent, trademark, and design rights. Secondly, the trial policy division is in charge of IP policy planning, revision on legal system, formality examination, and so on. Lastly, the litigation division handles litigation before the courts related to ex parte decisions made by the IPTAB. Let me explain about qualifications for administrative judges. Each board consists of 3 members. To become an administrative judge, one must have at least 2 years of experience as an examiner. Presiding administrative judges must have served as administrative judge for more than 2 years. They can also be appointed from a private sector who has extensive backgrounds as an attorney or patent attorney. IPTAB proceedings can be broadly divided into ex parte and inter partes. In ex parte proceedings, there are an appeal against an examiner's decision to reject the application, trial for collection, and patent opposition. In a patent opposition proceeding, anyone may challenge the validity of a registered patent within 6 months of publication of the grant of the right. The 2 main types of inter partes proceedings are trial for invalidation and trial to confirm the scope of rights. Interested part can file a petition for a trial to invalidate a granted right based on statutory invalidation grounds. A trial to confirm the scope of rights is the proceedings in which a patentee, exclusive licensee, or interested party may file a petition to have the scope of protection of the patent invention confirmed by the board. As you can see in the chart, there are 3 stages in IP system. The first is an examination phase. The keeper decides whether the IP rights can be granted or registered. Then the IPTF reviews the emergence, extinction, and the scope of rights. If parties are not satisfied with the IPTF decision, they can file an appeal before the patent court. The patent court has exclusive jurisdiction over infringement lawsuit appealed against 23 high courts and district courts. As a last resort, patent court decision can be appealed before the Supreme Court. Discussions are currently being made to consolidate jurisdictions over other IP litigation and civil cases on preliminary injunctions, criminal cases such as trade secrets, unfair competitions, and so on. Now we'll take a look at some current status and trends in IP trials and with some statistical data. The graph shows the number of cases filed in the past 5 years. There was a slow downward trend until 2022, but it recently showed some signs of recovery with 3,166 cases filed last year. The number of inter-parties cases has increased, and the number of petitions from foreign countries has gradually decreased, but the number of cases remains stable around 900. Let's look at some trends in 2024. Until August, IPTV received 1,685 cases filed, and 2,236 cases was disposed. On appeal against rejection took up the majority of the cases. If this trend continues, the number of cases this year is expected to decrease compared to last year. Here you will see the trends in revocation actions against IPTV decisions. The rate of revocation actions filed before the patent court has gradually increased, reaching 60.41% last year. On the other hand, the rate of IPTF decisions revoked by the patent court was 22.09% last year. It seems to reflect the tendency of increasing complexity of cases. In response, the IPTF has been implementing policies such as improving the oral hearings in order to increase user satisfaction and to ensure reliability of our decision. The IPTV pendency was gradually reduced and recorded 6.6 months last year. On average, pendency remains about 7 months. With the trends in reduced pendency, the number of oral hearings on the rise. The IPTV is striving to ensure prompt and reliable proceedings by having more cases to be heard. Finally, let's take a look at some key figures for 2024. While the rate of the cases affirmed in appeal against the rejection
is 27.5%. Those of trial for investigation and trial to confirm the scope of rights are relatively high, 44% and 56.5% respectively. This can be interpreted that there are more intense disputes in the inter-parties cases. In this regard, the IPTAB is further striving to improve the quality of its proceedings and decisions. For reference, the rate of IPTAB decisions revoked by court is around 20%. Lastly, I'd like to present some key developments in IP policies and practices in Korea. IPTAB has expanded the number of oral hearings in the case of inter-parties. It ensures prompt dispute resolution with points at issue, increases parties' acceptance of all the decision, and allow panels to have understandings of the case. Last year, patent court performance rate in IPTAB decision is 80.82% for cases in which oral hearings were held, higher than 72.5% for cases in which oral hearings was not held. Lastly, IPTAB was relocated to separate premises from the KOIPA office. It ensures fairness and independence of the IPTAB proceedings. With the relocation, IPTAB has expanded its facilities to provide better services to users. As shown in the table below, hearing room and case briefing room were added to Daejeon and Seoul office to accommodate a large number of hearings. For fair and professional judgment, IPTAB has established the system for IPTAB appointed attorneys, technical advisors, and makers query. IPTAB appointed attorneys provide support for financially or socially underrepresented inventors. Technical advisors who act as technical experts ensure reliability of IPTAB decisions. Makers queries legal expertise and opens to industry and hear feedbacks from public. In addition, there are also fast-track proceedings for SME and special court for far-reaching social impact, such as cases involving the depth of innovative technology from SMEs. Let's take a closer look at the makers query. Under the current law, there is no opportunity to hear public opinions from the third parties during the IPTAB proceedings, such as public institutions or other than parties concerned with interested party. Revisions are currently in progress to allow the presiding administrative judges to request public institutions, government or local government agencies to provide written opinions on trial and applications when deemed necessary for hearing the case. The makers query was launched in March 2024. More exclusive boards have been added for cases involving national critical technologies.
Exclusive board consists of highly experienced administrative judges who have academic background in specific field and extensive years of experience in examination and trial. They exclusively hear and review cases involving emerging and advanced technologies. IPTA introduced a new AI powered IT system. There has been a burden for the board in the number of cases reviewed for each administrative judge. It is necessary to enhance evidence examination. User expectations in customer service is becoming higher, including filing, submission, view, and issuing of IPTA document consultation. In this situation, advanced IT technologies such as high-performance hardware, user-friendly software, and AI are possible to enhance work efficiency and user experience. IPTA has established a 3-year plan for developing AI-powered IP system in 2022. It was carried out in 3 phases: more convenient e-filing system, AI-powered automatic formality check, and AI-powered trial support system. The first and second phases, which were pushed in 2023 and 2024, more convenient e-filing system and AI-powered automatic formality check system was built. Next year, IPTA aims to enhance AI-powered trial support system through automatic error detection of IPTA decisions and AI-powered search service in IPTA court decisions and so on. Advanced notice of date of IPTA decision was introduced to meet user satisfaction in July 2023. In the future, when notifying the case to be closed, IPTA will also notify the date when trial or appeal decision is to be made, and the decision will be rendered as scheduled. Lastly, there are some revisions in fast-track proceedings for cases requiring urgent review. Maybe it is similar to USPTO. Similar cases will be combined and removed to improve convenience. For reference, prioritized track takes 6 months and accelerated track takes 3 months, twice as fast as prioritized track. Cases considered relatively less urgent will no longer be handled under the fast track. This is to prevent excessive delays in regular track proceedings. That's all I have prepared for you today. Thank you for your attention.
Good afternoon, everyone. I'm an attorney, Sinjung Lee of DR and Aju LLC in Seoul, Korea. It's an honor to be a part of 2024 Korea U.S. IP Forum. Today, I will talk about the types of IP litigation, the characteristics of litigation proceedings at IP High Court, and the international IP disputes taking place in Korea. First, regarding the types of IP litigation. IP litigation includes 2 types: suits against administrative decisions rendered by Intellectual Property Trial and Appeal Board, and civil actions relating to IP rights. Suits against administrative decisions are such as suits seeking the revocation of the following: trial decision to revoke rejection of a patent application, decisions to nullify a patent right, and decisions to conform the scope of rights. Suits against administrative decisions are handled under a two-level trial system. The IP High Court has the exclusive jurisdiction of the first instance trial. In reputation cases, appeals may be made to the Supreme Court only when the IP High Court decisions violate the law. Civil actions relating to IP rights include actions seeking the injunction, destruction, and damages against infringement of patent, design, and trademark rights. Civil actions relating to these rights are under the exclusive jurisdiction of 6 district courts. Appeals against the first instance decisions are brought before the IP High Court. The IP High Court decisions may be appealed to the Supreme Court solely on the ground of a violation of the law. On the other hand, civil actions based on the Copyright Act and the Unfair Competition Prevention and Trade Secret Protection Act may be filed with the district courts nationwide in the same manner as general civil actions or administrative actions. Next, on the topic of the characteristics of litigation proceedings and patent court. The patent court is the former name of IP High Court. Korea now decides to use IP High Court rather than patent court for the English term. 1. Technical examination. The patent cases involve technological matters that require specialized knowledge and experience of a specific technical area. The IP High Court has a pool of judicial technical examiners, judicial research officers, and technical advisors to resolve disputes effectively through specialized examination of technological matters. They are hired to help the judge to understand the substance of arts in patent litigation. 2. Evidence collection system. In order for a patent owner to secure his rights in patent litigation, it's crucial to collect evidence effectively. Korea has a regulation on its evidence collection system. These systems include the document submission order system under the Civil Procedure Act, the material submission order system, and the obligation to present specific modes of conduct under the Patent Act. The Patent Act introduced the material submission order system and the obligation to present specific modes of conduct to resolve difficulties in protecting rights due to the maldistribution of evidence in patent litigation. However, the general assessment of the present system is that it does not prove to be helpful to plaintiff as expected. Because of this, Korea endeavors to introduce a new evidence collection system. Since 2020, the Korean Intellectual Property Office and the National Assembly have been jointly promoting the introduction of Korean-style evidence collection system to overcome the shortcoming of the present system. 3. Electronic case filing system and video trials. In 2010, the IP High Court has provided electronic case filing system that allows the parties to file complaints, submit brief and evidences, and access case process through the electronic devices. Additionally, video trials are implemented in patent litigation. Video trials refer to trials in which parties, witnesses, and experts participate in proceeding through video conferencing equipment without appearing in person in court. Last topic is international IP disputes. The IP High Court handles international IP disputes. To provide convenience to the international disputes, the amended Court Organization Act, effective from June 13, 2018, established the international divisions. A case may be brought to the international divisions if a party to the lawsuit is a foreigner or a foreign company, or there are other circumstances that make the case international in nature. Consequently, parties can make oral arguments or submit documents in foreign language in Korean courts. However, considering the market size and the corresponding amount of damages, it's hard for Korea to be selected as a dispute resolution venue, even though it implements policies favorable to patent owners. Currently, using the Unified Patent Court as a role model, the Supreme Court has begun the groundwork to create a new international IP dispute resolution system, such as the Asian Union Intellectual Property Court. This concludes my presentation. Thank you for your time.
Second part of our presentation is about the approaches for cross-border litigation, e-discovery involving Korean companies. My name is No, and I'm working at International Practice Group in DR Naju LLC, South Korean law firm. And our team is very actively engaged in various litigation and investigation in the US for Korean companies in assisting with the discovery process. And there has been an increase in patent cases filed in the US ITC or the US District Court instead of a Korean court between the Korean competing Korean companies. You may know that recently there were disputes between some EV battery manufacturing companies and the Botox manufacturing companies. There are these disputes in the US. And this trend is likely due to the importance of the US market and the substantial damages associated with the infringement of the patent, but especially discovery process. So in the Korean judicial system, the party bearing the burden of proof is also responsible for submitting evidence, which makes it very challenging to prove the infringement and the amount of damages. We do have a similar process like the US discovery, as Ms. Lee explained, such as the party may request the court to order the submission of document if certain requirements are met, and the court may compel the other party to submit documents or materials for materials under the Korean Civil Procedure Act or Korean Patent Act. However, it is practically inefficient because the other party may refuse to produce the document as these are some trade secret, or the other party can edit or redact or partially produce the document in their favor. And this is very difficult to verify this. And according to the status from the 2023 IP trend published by Korean International Intellectual Property Office, the Korean companies face about around 100 patent cases every year in the United States. The large corporation account for a significant portion of this lawsuit, but small-sized or medium-sized enterprise in Korea also have about 20 to 30% of all patent cases in the US. Large corporations have the enough human resources and know-how and extensive litigation experience in the US, but small and medium-sized enterprise often they do not have. And particularly, they are not familiar with the discovery process. So you may know very much, but let me introduce some practical point of what you need to keep in mind from a discovery perspective. based on our experience. So first of all, you should provide some guidance on the litigation hold, as Mr. Kim already mentioned. It's typically handled by an in-house counsel or in-house legal team, but it's sometimes overlooked, especially in the case of small and medium-sized enterprise. Regarding the timing, you need to consider on the litigation hold even at the very early stage when the claim letter has been served. In terms of the scope of the document preservation, as Korean companies tend to see only the R&D department or engineers as relevant, but you need to consider to include the finance, sales, or marketing, or some other relevant department as well. And also, it is very important to note that some Korean companies do not have any internal document retention policies. And even if such policy exists, there may be some instance where the documents are not stored or disposed according to such policies. So therefore, it is crucial to first verify whether there is any internal document policy and whether the document retention or disposal are being conducted according to that policy. Regarding collection, it is important to consider the collection of data from key custodians' desktop or laptop PCs in order to protect against some potential discovery challenges from the opposing party in relation with the document preservation. And when you review the document, especially internal reporting document, are very important because most of hot docs are found in internal reporting document as well as emails. As a side note, Korean companies' reporting document typically condense a lot of information into 1 or 2 pages. So you need to be careful of the abbreviation or acronyms. And also, you will also need to be mindful of confidentiality and privilege determination, especially if the document contains some in-house or outside Korean legal counsel, or in-house or outside Korean patent attorneys. Finally, in production of document, it is important to review whether or not they qualify as national core technologies. As discussed this morning, under the Industrial Technology Protection Act, the national core technology means a technology that has a high technical and economic value in the domestic and international market, or a high growth potential in related industry, which if leaked abroad may have a significant adverse effect on the national security and development of the national economy. So based on the most recent notice published by the MOTI, the NCT, the National Core Technology, has designated 76 technologies in 13 technology fields, such as semiconductor, display, automobile, steel, shipbuilding, and etc. So production of document containing NCT may constitute the export of NCT under the relevant act, which requires the approval of the MOTI in advance or prior notification to MOTI under the act. And also, not only the production of document, but also the transfer of document to servers in foreign countries for hosting for your document review may also constitute the export of the national core technologies. So you may need to review in advance. So these are some practical points to keep in mind in discovery process involving Korean companies. So in particular, the small size and medium size enterprise in Korea, they may have some hurdles for in the U.S. litigation, and especially the discovery, because they have some kind of the communication difficulties or insufficient support due to they do not have any legal team or in-house counsel, and they are not familiar with the discovery process. So, as these details will be critical for a successful defense, therefore it is advisable to consider the appointment of a Korean law firm as a discovery local counsel in Korea that has a strong understanding of the discovery process and Korean business culture. Thank you.
Hello, I'm Yong-Ha Kim, the Director and Managing Attorney at KOIPA's U.S. Capital IP Center. It is an honor to be a part of 2024 Korea U.S. IP Forum, and I appreciate this opportunity to introduce KOIPA's U.S. IP Center. In response to the growing awareness and importance of IP in the global economy, the Korea Intellectual Property Office, KIPO, has operated a network of IP offices since 2008 to provide comprehensive IP support, focusing on regions with active IP issues. Our U.S. Capital IP Center was originally established in 2013 under the name Kotra New York IP Desk and has operated in New York for the past decade. Following a comprehensive reorganization on January 1st this year, we are now part of KOIPA, an agency under the Korea Intellectual Property Office. KOIPA transformed the IP desk, originally covering just 11 countries, into wide area IP centers and expanded the existing program to eventually cover 40 countries. Now we are covering 32 countries. We have 2 offices in the United States, one in the Washington, D.C. metro area and one in LA. Each IP center in the US provides IP guidance for Korean small and mid-sized companies to enter the US market. KOIPA's US Capital IP Center is located Tyson's Corner near Washington, D.C. Our center covers the entire eastern United States, including Boston, Washington, D.C., New York City, Atlanta, and Chicago. We welcome any Korean small and mid-sized companies seeking intellectual property rights assistance. KOIPA's U.S. Capital IP Center works in a variety of ways to achieve its mission. KOIPA's U.S. Capital IP Center services can be broadly divided into 3 different categories. First, assistance with IP rights. The IP Center provides assistance regarding the acquisition and protection of US IP rights. We also provide initial response guidelines for businesses that have been sued or received the court submissions in the United States. Second, information services. The IP Center actively educates the public about US IP laws through seminars and various channels of communication. We collect up-to-date information regarding current US IP litigation trends to help prevent and avoid potential conflicts. The IP Center monitors national and international industries and related patent activities to identify and predict potentially problematic patents and to provide early warnings for potential conflicts. We created databases of US attorneys and provide them to Korean businesses that may need access to such information. Lastly, subsidizing IP application fees and costs. The IP Center provides subsidies for patent and trademark applications and legal opinion letters. Our patent and trademark application subsidy program offers 50% of attorneys' fees for small and mid-sized companies. We are providing up to $2,500 per patent case, $1,500 per design patent case, and $700 per trademark cases. The maximum amount of subsidies one company can receive through the program is capped $5,000 per year. Only on individual, small or mid-sized companies registered as a business in South Korea that operates or plans to operate a business in the US can apply to this program. The IP Center also provides subsidies for legal opinion letters. The legal opinion letters subsidy program provides subsidies for conducting patent infringement analysis, such as freedom to operate, reviewing non-disclosure agreements, and drafting legal memorandums responding to legal disputes related to IP, with a specific focus on the pre-litigation stage. We provide strategic advice and support to Korean small and mid-sized companies before legal disputes escalate to the full-blown litigation stage. Our program offers 70% of attorney's fees for small companies and 50% fees for mid-sized companies, up to $10,000 per case with a maximum of 2 cases per year per company. Every year, KOIPA attends various trade shows and seminars where we counsel companies on how to best protect their IP rights, including patent trademarks, copyrights at the event. We offered these services online, especially during the pandemic, which were very well received as many companies were able to participate regardless of their location. We still host frequent webinars, and twice a year we hold a legal business consultation program where we bring in experts in their respective fields to provide free 30 minutes consultation to companies. The photo on the left shows a webinar on the latest developments in the US IP law, and policy that we hosted in 2021 during the height of the corona pandemic. The speakers were Andrei Yanku, former US Undersecretary of Commerce for Intellectual Property and Commissioner of Patent and Trademark Office, and Vincent Gallup, Director of AIPLA, providing in-depth discussion. The US IP Center also has a YouTube channel that provides a basic but practical overview of US patent and trademark law, features many of our past seminars and webinars. We invite you to check it out. These are some of the seminars that US Capital IP Center has organized in collaboration with the Korea Society and the Global Open Innovation Platform, SOSA New York. In addition to large-scale seminars with more than 100 participants, the US Capital IP Center frequently organizes smaller seminars where companies can hear from industry experts in more intimate setting. Each month, the US Capital Center updates its newsletter subscribers with the latest intellectual property trends, rotating through topics of interest to businesses such as patents, trademarks, copyrights, and trade secrets. We also collect all the newsletters sent out each month and publish them in a book at the end of the year. In addition to our annual newsletter compilations, we often publish books covering subjects ranging from the latest development in the US IP policy to IP topics of interest to startups. KOIPA's US Capital IP Center is the first contact point reached out to by Korean companies in need of help with their IP matters. And we will serve as a bridgehead for Korean companies seeking to acquire and protect their IP rights in the US. We are committed to providing our best efforts in helping Korean businesses with their IP journey. Please reach out to us if you have any IP needs. Thank you so much.
afternoon, everyone. It's a pleasure to be here today. My name is Taehyun Lee. I'd like to give you a brief presentation regarding KOIPA's PCT services. First, I'd like to show you some IP statistics and then explain in further detail about the Korea government's PCT services. This graph shows PCT application trends. Between 2003 and 2023, PCT applications have steadily increased, and the number of PCT applications has more than doubled in the last 20 years. This graph shows PCT application by country in 2023. Among IP5 countries, Korea recorded the sharpest increase. Korea's PCT application growth rate was 1.2%. In the same year, PCT applications were highly concentrated in just a few countries, such as China, the US, Japan, and Korea. Regionally, Asia accounts for 55.6% of total PCT application. This slide shows the top PCT applicants in electrical engineering sector. Most applicants were based in Asia, such as Huawei, Samsung, LG Electronics, and LG Energy Solution. Now, I'd like to talk a bit about IP services at KOIPA. Approximately 1,800 staff members work at KOIPA, and almost half of them are specialists in fields like IP law, science, engineering, and so on. KOIPA regards examination quality as the most important goal in order to maintain the highest quality of PCT application and PCT examinations. These PCT-related divisions collaborate often and effectively. This graph shows an interesting statistic. While other search authorities mostly cite literature from their own languages, KOIPA use documents published in various languages, making their searches much more balanced. It's because that most KOIPA examiners can directly understand English and Japanese documents. I want to emphasize that this is one of the outstanding strengths of KOIPA. When it comes to PCT search fees, KOIPA provides a very fair price. It's nearly half the price of EPO search fee. There are so many countries that select Korea as their international searching authority. In 2009, KOIPA made a branch in America that has provided local services regarding PCT-related issues for over 10 years. KOIPA is the first and only foreign ISA to have a help desk in the US. If you have any questions and feedback, please don't hesitate to contact us. Thank you.
Thank you very much, Mr. Lee. This concludes all the lectures scheduled for today. We would like to inform you that the KOIPA U.S. Capital IP Center and PCT Korea will be conducting on-site IP consultations for inquiries or issues pertaining to intellectual property, entrepreneurial strategy, or other related matters. The consultation tables have been arranged at the back of this room. You can easily find them with their displayed banners. For those who have registered for the USPTO tour, the tour begins around 2:30 at the registration desk where you checked in and received your name tag.
We are fortunate to have Mr. Thomas Hong, a patent examiner at the USPTO, as your tour guide for today. Please remember to bring your government ID as it will be required for the tour. We have prepared a small token of appreciation for all of you who joined us today. In order to make sure everyone gets a chance, please take only one gift per person. You can collect it at the registration desk as you exit. If any of you wish to join us for dinner beginning at 4:30 p.m., you're most welcome. We'll be dining at Whiskey and Oyster, which is a 5-minute walk from this hotel. If you have any further questions, please do not hesitate to ask any of our staff members at the registration desk. For those of you who do not plan to participate in the consultations or the tour, we express our sincere gratitude for your attendance at today's event. We hope that you have gained valuable insights into topics related to intellectual property. Again, thank you for being a part of this event, and we look forward to future engagements. Thank you.